Hello friends, welcome to EPG Pathshala. I am Dr. Ajay Solkhe, presently working as Assistant Professor, University School of Management, Kurukshetra University, Kurukshetra, Haryana. Upon completion of the module, the students should be able to understand the legal framework on wages in India, the major legal provisions outlining payment of wages norms as well as minimum wages, clauses relating to authorized deductions from wages finally given to workers, inclusions in minimum wages, how it is fixed and revised, and the procedure for the same, authorities for the enforcement of these acts, penalties and offences under the Wages Acts. Legal framework on wages in India. The legal framework for the payment of wages salaries is governed mainly by four legislations. Besides the guidelines for managerial remuneration and relevant provisions in the Indian Companies Act, here we will consider mainly two legislations, the Payment of Wages 1936 and the Minimum Wages Act 1948. Legal provisions of Payment of Wages Act 1936. Very first of all, we need to examine what are the objects behind passing of this act. The Payment of Wages Act 1936 regulates the payment of wages to certain classes of persons employed in industry. It was formed to ensure that the wages payable to employees covered by the act are disbursed by the employer within the prescribed time limit and that no deductions other than those authorized by law are made by the employer. As of 1st January 1996, the law was last amended through the Payment of Wages Amendment Act 1982, which came into effect on 15th October 1982. The main provisions of the Act are discussed below. The very first of all, it will discuss the coverage and the applicability. The Act applies to persons employed in any factory and persons employed in the railways either directly or through a subcontractor. Further, the state governments, they are quite empowered to extend the provisions of the Act to cover persons employed in any industrial establishment or any class or group of industrial establishment as defined in the Act. The wage limit for the applicability of the Act is Rs 6,500 per month. Responsibility for payment of wages. Employers, managers of factories and or the person responsible for the supervision and control of the industrial or other establishments, they are responsible for the payment of wages. Fixation of wage periods. Those responsible for payment of wages shall fix the wage periods in respect of which wages are payable and such periods should not exceed 1 month. Time of wage payment rules. Section 5. The following rules have been laid down regarding the time of payment of wages. Very first of all, if the number of persons employed in a factory, an industrial establishment or railways including daily rated workers is less than 1000, wages must be paid before the expiry of the 7th day after the last day of the wage period. In other cases, wages must be paid before the expiry of the 10th day after the expiry of the wage period. In the case of persons employed in dock, mine, wharf or jetty, the balance of wages found due on completion of the final tonnage account of the ship or wagons loaded or unloaded shall be paid before the expiry of the 7th day after such completion. Where the employment of any person is terminated by or on behalf of the employer, the wages earned by him shall be paid before the expiry of the second working day from the day on which employment is terminated. If the employment is terminated due to the closure of establishment for any reason other than a weekly or other recognized holiday, wages will be paid before the expiry of second working day from the day on which employment is being terminated. The state government may by a general or special order exempt the person responsible for the payment of wages from the operation of the above provisions in certain cases. All payment of wages shall be made on a working day. Deductions. The wages of an employed person shall be paid to him without deductions of any kind except those authorized under the Payment of Wages Act. This is notwithstanding the provisions of Section 47 of the Indian Railways Act 1890, Section 7. There are various kinds of deductions. The very first of all, deductions relating to fines as stipulated in Section 8. Section 9 clearly specifies the deductions for absence from duty in lieu of notice. Section 10 specifies the deductions for damage of loss. Section 11 specifies the deductions for accommodation and service. Under Section 12, deductions for recovery of advance has been mentioned. Under Section 12, subsection A, deductions for recovery of loan has been mentioned. Deductions for payment to cooperative societies and insurance scheme has been stipulated in Section 13. And lastly, there are certain other set of deductions which are clearly mentioned as far as this act is concerned. Under section 8, fines. Provisions regarding fines are as follows. No fine shall be imposed on any employed person except in respect of such acts omissions on his part as the employer, with the previous approval of the state government or of the prescribed authority, may have been specified by a notice. Secondly, the notice specifying the acts and omissions for which fines may be imposed shall be exhibited in the prescribed manner on the premises or a place in which the employment is carried on. Thirdly, no fine shall be imposed on an employed person until he has been given an opportunity of showing cause against the fine. Fourthly, the total amount of fine in any one wage period on any employed person shall not exceed 3% of the rupee wages payable to him in respect of that wages. Subsequently, no fine shall be imposed on a person who is below the age of 15 years. No fine shall be recovered from the employed person by installments or after the expiry of 60 days from the day on which it was imposed. Every fine shall be deemed to have been imposed on the day of the act or omission. All such fines and realizations thereof shall be recorded in a duly maintained register to be kept by the person responsible for the payment of wages in such form and manner as may be prescribed. All realizations of fine shall be applied only to such purposes as are beneficial to the persons employed in the factory. Under section 9, provisions relating to deductions for absence of duty has been mentioned. Very first of all, deductions may be made on account of the absence of an employed person from duty from the place or place where by the terms of employment he is supposed to work. Secondly, an employed person shall be deemed to be absent from duty if through present at the place of work he refuses to carry out his work in pursuance of a stay-in kind of strike or for any other cause which is not at all reasonable. Lastly, the ratio between the amount of deductions for absence from duty and the wages payable shall not exceed the ratio between the period of absence and total period within such wage period. If, however, 10 or more persons acting in concert absent themselves without any due notice and without any reasonable cause, the deduction for absence from duty from any such person may include such amount not exceeding his wages for 8 days as may be due to the employer in lieu of a notice. Subsequently, a deduction for damage to or loss or goods expressly entrusted to the employed person for custody or for loss of money which is required to account for can be made where such loss is directly attributable to his neglect or willful default. A deduction for damage or loss shall not exceed the amount of damage or loss caused to the employer by his neglect or default. A deduction for damage or loss shall not be made until and unless the employed person has been given an opportunity of showing cause against the deduction. All such deductions and realization in respect of damage or loss shall be recorded in a register to be kept by the person responsible for the payment of wages. Deductions for accommodation and service. These provisions are stipulated in section 11 of this act. Deduction for house accommodation and amenities and service supplied by the employer can be made subject to the following conditions. Very first of all, deductions cannot be made unless such services have been accepted by the employed person as a term of his employment. Services do not include the supply of tools and raw materials required for the purpose of the employment, and no deduction can be made in that respect. The amount of deduction cannot exceed an amount equivalent to the value of house accommodation, amenity or service supplied. The amenities and services must be authorized by the state government by a general or a special order. State governments are empowered to make rules governing deductions for amenities and services. Under section 12, provisions relating to deductions for recovery of advances have been stipulated. Firstly, deductions for recovery of advances or adjustments of overpayment of wages can be made subject to the fulfillment of certain conditions. Very first of all, recovery of an advance of money given before employment shall be made from the first payment of wages in respect of complete wage period, but no recovery can be made of such advance given for travelling expenses. Recovery of an advance of money given after employment began shall be subject to certain conditions as the state government may impose. Recovery of advances of wages not already earned shall be subject to any rules made by the state government in this regard. The state government may regulate the extent to which such advances may be given. the installment by which they may be recovered, and the rate of interest that may be charged on such advance. Deductions for recovery of loans has been stipulated under section 12 subsection A. It specifies that deduction for recovery of loans made from any fund constituted for the welfare of labour and the interest due in respect thereof can be made provided the fund is constituted in accordance with the rules approved by the state government. Deductions can be made for recovery of loans granted for house building or other purposes approved by the state government and the interest due in respect thereof. Under section 13, deductions for payment to cooperative societies and insurance scheme has been stipulated. The deductions include, very first of all, deductions for payment to cooperative societies approved by the state government or to a scheme of insurance maintained by the Indian Post Office. Deduction made with the written authorization of the person employed for the payment of any premium on his life insurance policy to the Life Insurance Corporation of India or for the purchase of any kind of securities of the Government of India or of any state government or for being deposited in a post office saving bank in furtherance of any saving scheme of any such government. Lastly, these deductions shall be subject to such conditions as the state government may impose. The other set of deductions which has been mentioned in this Act, the following deductions are also permissible, naming a few is deductions of income tax payable by the employed person, deductions required to be made by order of the court, deductions for subscriptions to and for repayments of advances from any provident fund to which the Provident Fund Act 1925 applies or any recognized provident fund or any provident fund approved in this behalf by the state government. Deductions for payment of insurance premia of fidelity guarantee bonds. Deductions made with the written authorization of the employed person for the payment of his contribution to any kind of fund which is constituted by the employer or trade union registered under the Trade Union Act 1926 for the welfare of the employed person or the members of their families or both and approved by the state government or any officer specified by it on behalf during a continuing of such approval. Deductions made with the written authorization of the employed person for payment of the fees payable by him for the membership of any trade union registered under the Trade Union Act 1926. Deductions for recovery of losses sustained by a railway administration on account of acceptance by the employed person of counterfeit or base coins or mutilated or forged currency notes. Deductions for recovery of losses sustained by a railway administration on account of failure of the employed person to invoice, to bill, to collect or to account for the appropriate changes due to that administration, whether in respect of freight fares, demurrage, warfare or carriage, and respect of sale of food in catering establishment or in respect of sale of commodities in the grain shops or otherwise. Deductions for recovery of losses sustained by a railway administration on account of any rebates of refunds incorrectly granted by the employed person where such loss is directly attributable to his neglect or default. Deductions made with the written authorization of the employed person for contribution to the Prime Minister's National Relief Fund or to any other such fund as the central government may by notification in the official gazette specify. Deductions for contribution to any insurance scheme framed by the central government for the benefit of its employees. And lastly, the list of deductions in section 7 subsection 2 is an exhaustive list. Further, if any deduction is claimed by any employer, the burden specifically and clearly lies upon him to prove that the deduction is of such nature which is capable of falling within the several clauses of section 7 subsection 2. Illegal deductions. Any deduction other than those authorized under section 7 of the Act would constitute illegal deductions. Section 7 subsection 5 specify the provisions relating to the limits on the amount of deduction. The very first of all is the total amount of deduction which may be made under section 7 in a wage period from the wages of any employed person shall not exceed 75% of such wages in cases where such deductions are wholly or partly made for payments to cooperative societies. In any other case, the deduction shall not exceed 50% of such wages. Secondly, any agreement or contract by which an employee agrees to any deductions other than those authorized under the Act would be null and void under section 23 of the Act. There is, however, no provision in the Act limiting the period within which the employer should make the deductions for adjustment of overpayment of wages. Maintenance of registers and records. These provisions have been specified in section 13 subsection A. Every employer must maintain registers and records giving the following particulars of every person employed by him. Specifically, he should mention in his registers the work performed by the person employed, the wages paid to him, the deduction made from his wages, the receipts given by him. All such registers and records shall be in such form and manner as may be prescribed. They shall be preserved for a period of 3 years after the date of the last entry made therein. Appointment of competent authority. The state government may by notification in the official gazette appoint a person as the authority to hear and decide for any specified area all claims arising out of the deductions from the wages or any such delay in payment of the wages of persons employed or paid in that area, including all matters incidental to such claims. The following may be appointed as the competent authorities. Very first of all, a presiding officer of any labour court or industrial tribunal constituted under the Industrial Dispute Act 1947, or any commissioner for workmen compensation, or any other officer with the experience as a judge of a civil court or as a stipendiary magistrate. Every authority so appointed shall have the powers of a civil court under the Code of Civil Procedure 908. The provisions relating to claims. Where contrary to the provisions of this Act, any deduction has been made from the wages of an employee or any payment of wages has been delayed, such persons may apply for direction. Application must be made within 12 months from the date of deduction or from the date on which the payment was due. The authority has the power to accept any delayed application. The authority may, after hearing both the persons, direct the payment. Compensation may be 10 times the amount deducted or Rs 25 in case of delayed wages. No compensation shall be made in the case of delayed wages if the authority is satisfied that the delay was due to a bona fide error or dispute regarding the amount payable to the employed person, the occurrence of an emergency, or the existence of exceptional circumstances such that the person responsible for the payment of wages was unable, though exercising reasonable diligence, to make prompt payment, and lastly, the failure of the employed person to apply for or accept payment. If the authority hearing an application is satisfied that the application was either malicious or vexatious, the authority may direct that a penalty not exceeding 50 rupees be paid to the employer by the person presenting the application. Provisions relating to penalties. Penalties have been provided for contravention of various provisions of the Act, varying from a fine of Rs 500 to Rs 1000. For failing to maintain prescribed registers or records, refusing to give information, or furnishing false information, punishment may be in the form of a fine which may extend to Rs 500. For obstructing an inspector, refraining to produce any document to the inspector, or preventing anybody from appearing before or being examined by an inspector, punishment may be a minimum fine of Rs 200 or may extend up to Rs 1000. If any person who has been convicted is again guilty of an offence involving contravention of the same provision, he shall be punishable with imprisonment for less than 1 month, which may extend to 6 months, or with a fine not less than Rs 500, which may extend to Rs 3000. If any person fails or wilfully neglects to pay the wages of any employed person by the date fixed by the authority, he shall be punishable with an additional fine of Rs 100 for which each day such failure or neglect continues. Introduction, objects, scope and applicability of the principal objective of the Minimum Wages Act 1948 is to prevent exploitation of labour through the payment of unduly low wages. The Act provides for fixing the minimum rate of wages for certain employments specified in the schedule. Besides, the National Commission on Labour has recommended the extension of the principle of minimum wages to non-scheduled employments also. Under the Minimum Wages Act, minimum rates of wages are not at all fixed in respect of all employments. They are fixed only in respect of certain employments specified in the schedule to the Act. The government may, however, make additions to the list of employments contained in the schedule. Therefore, the number of employments added to the schedule varies from state to state. As of now, this is only about 40 with respect to the central government and about 1200 in case of the state governments. The Minimum Wages Act does not define minimum wage and does not contain any guideline regarding what elements should be taken into consideration in prescribing a minimum wage. As a result, different wage fixing authorities have followed different sets of principles in fixing or revising the minimum wages. There are wide disparities in the rates of minimum wages fixed in respect of different employments within the state and in respect of the same employment fixed by different states. Fixation of minimum wage. Minimum rate of wages. Here the government may fix 4 categories of rates. The very first of all, they can fix a minimum time rate, they can fix a minimum piece rate, they can fix a guaranteed time rate, and lastly an overtime rate which is appropriate to different occupations, localities or classes of work and for adults, adolescents, children and apprentices. The minimum rate of wages may consist of 3 things. Very first of all, a basic rate of wages and a cost of living allowance. Secondly, a basic rate of wages with or without the cost of living allowance and the cash value of the concessions in respect of supplies of essential commodities at concessional rates. Thirdly, an all-inclusive rate allowing for the basic rate, the cost of living allowance and the cash value of the concessions. Minimum wages shall be paid in cash, although the appropriate government may authorize the payment of minimum wages either wholly or partly in kind in particular cases. Procedure for fixing and revising the minimum wages. The Act prescribes for the fixation and revision of minimum rates of wages in respect of any scheduled employment. The Act provides for the appointment of committees and subcommittees to hold inquiries and advise the appropriate government in fixing and revision the minimum rate of wages, and to appoint an advisory body for the purpose of coordinating the work of committees and subcommittees and also for advising the appropriate government generally in the matter of fixing and revising the minimum rate of wages. A central advisory board shall be appointed for advising the central and the state governments and for coordinating the work of the advisory boards. All these bodies are tripartite in composition, consisting of persons nominated by the appropriate government representing the employers and employees concerned, and independent person not exceeding 1/3 of the total number of members. One of the independent persons shall be appointed as the chairman by the appropriate government. The appropriate government has to consider all representations received by it before the date specified in the notification. They should consult the advisory board and fix and revise, as the case may be, the minimum rate of wages by a notification in the official gazette. Unless the notification provides otherwise, it takes effect on the expiry of 3 months from the date of its issue. Advisory board and its composition. For the purpose of coordinating the work of committees and subcommittees appointed under Section 5 of the Act and advising the appropriate government generally in the matter of fixing and revising minimum rate of wages, the appropriate government shall appoint an advisory board to function. It can devise its own procedure. Composition of committees and advisory board. Under Section 9, the provisions have been specified. Very first of all, each of the such committee or subcommittee and the advisory board shall consist of persons to be nominated by the appropriate government representing employers and employees in the scheduled employments, who shall be equal in number and independent person not exceeding 1/3 of its total number of members. And one of the independent persons shall be appointed by the appropriate government as the chairman of the committee. An official of the government can be appointed as an independent person. Under Section 8, Central Advisory Board has been constituted. The central government shall appoint a Central Advisory Board for the purpose of advising the central and the state governments in the matter of fixation and revision of the minimum rate of wages and the matters under the Act, and for coordinating the work of the advisory board. It shall consist of persons nominated by the central government representing employers and employees in the scheduled employments, who shall be equal in number and independent person not exceeding 1/3 of its total number of members. And one of the independent persons shall be appointed as the chairman of the board by the central government, as specified in Section 8, subsection 2. Wages in kind. Minimum wages necessarily needs to be paid in cash, but where it has been the custom to pay wages wholly or partly in kind, the appropriate government may, by notification in the official gazette, authorize the payment of minimum wages either wholly or partly in kind, as specified in Section 11, subsection 2. The appropriate government may also, by notification in the official gazette, authorize the provision of the supply of essential commodities at concessional rates, as specified in Section 11, subsection 3. Section 11, subsection 4 specifies that the cash value of the wages in kind and of concession in respect of supply of essential commodities at the concessional rates authorized under section 11.2 and 11.3 shall be estimated in the prescribed manner. Tools regarding working hours. The government may also fix the number of hours of work, provide for a weekly day of rest, payment of remuneration in respect of such days of rest, and payment for work on a day of rest at a rate not less than the overtime rate. Rules regarding overtime. Where an employee works on any day in excess of the number of hours constituting a normal working day, the employer shall pay him at the overtime rate fixed under this act or under any law of the appropriate government, whichever is higher. Section 16 specifies the provisions relating to wages for two or more classes of worker. Where an employee does two or more classes of work, to each of which a different minimum rate of wages is applicable, the employer shall pay to such employee in respect of time respectively occupied in each such class of work wages at not less than the minimum rate in force in respect of each such class. Minimum time rate wages for piecework, section 17. Where an employee is employed on piecework for which minimum time rate and not minimum piece rate has been fixed under the Act, the employer shall pay to such employee wages at not less than the minimum time rate. Employer's obligation. Once the minimum rate of wages are fixed or revised according to the procedure prescribed under the Act, it becomes the legal obligation of the employers to pay the rates. They cannot plead the incapacity of the industry to pay. Enforcement of the Act. In enforcement category, we have very first of all under section 19 inspectors. By notification in the official gazette, the appropriate government may appoint inspectors and they define the local limits within which they shall exercise their functions. Under section 20 claims, the appropriate government may by notification in official gazette appoint an authority to hear and decide for any specified area all claims arising out of payment of less than the minimum rate of wages or for work done on days of rest or in respect of the wages at the overtime rate to employees employed or paid in that area. The authority for hearing and deciding claims. The authority to be appointed may be any commissioner for workmen compensation or any officer of the central government exercising functions as labor commissioner for any region or any officer of the state government not below the rank of a labor commissioner or any other officer with an experience as a judge of a civil court or as a stipendiary magistrate under section 20 subsection 1. Section 22 and 22A delineates the provisions relating to offences and penalties. Any employer who pays to any employee less than the minimum rate of wages fixed for that employee's class of work or less than the amount due to him under the provisions of the Act or contravenes any rule or order made under section 13 shall be punishable with imprisonment which may extend to 6 months or with fine which may extend to rupees 500 or with both things. In imposing any such fine, the court shall take into consideration the amount of any compensation already awarded against the accused in any proceedings taken under section 20. Friends, I hope you have understood the contents well. You can also refer to other quadrants of this module for testing your knowledge and having some more input on theme of the module. Happy learning.